Michigan gives landlords broad freedom to set and raise rent. But the state's framework has some unique characteristics that landlords need to understand, including the interaction between the state's Truth in Renting Act and rent increase practices. The governing law is found in Michigan Compiled Laws, Chapter 554, along with the Summary Proceedings Statute in MCL Chapter 600 and the Truth in Renting Act in MCL 554.631 through 554.641. If you manage rental property in Michigan, you have significant pricing flexibility, but the details matter. Michigan does not have statewide rent control or rent stabilization. There is no state statute that caps rent increases, limits the frequency of increases, or requires landlords to obtain government approval before raising rent. Michigan's political and regulatory environment has generally favored market-based pricing, and rent control has not been enacted at the state level. However, and this is an important distinction, Michigan does not have a statewide preemption statute that explicitly prevents local municipalities from enacting their own rent regulations. Michigan's Constitution grants cities and villages significant home rule authority, which means that a municipality could potentially attempt to enact local rent control. While no Michigan city has enacted traditional rent control to date, the absence of a preemption statute means the door isn't legally shut. This matters because several Michigan cities have been actively discussing housing affordability and tenant protections. Detroit, Ann Arbor, Grand Rapids, and other cities have seen political activity around rental housing issues, and tenant advocacy organizations in these communities have pushed for various forms of additional regulation. Landlords in Michigan's larger cities should monitor local legislative activity for potential changes. Ann Arbor, in particular, has a history of tenant activism driven by its large student population and progressive political culture. The city has enacted various tenant protection measures over the years, and the conversation around rent regulation has been ongoing. While Ann Arbor hasn't enacted a rent cap, landlords in the city should be aware of the political environment. For month-to-month tenancies, the landlord must provide advance written notice before a rent increase takes effect. Michigan requires at least one full month's written notice before changes to the terms of a monthly tenancy. So if rent is due on the 1st and you want the increase to take effect on May 1st, you need to deliver the notice before April 1st. The notice should be in writing and should clearly state the current rent, the new rent amount, and the effective date. Michigan doesn't prescribe a specific statutory form for rent increase notices, but a clear written notice delivered by a documented method, personal delivery, first-class mail, or another verifiable method, is essential. For fixed-term leases, the rent is locked in for the duration of the lease term unless the lease includes a provision allowing midterm increases. Without such a provision, the landlord must wait until the lease expires to negotiate a new rent. When the lease approaches expiration, the landlord should communicate the proposed new rate well in advance to give the tenant time to evaluate the new terms and decide whether to renew. If the tenant doesn't agree to the new rate, the lease expires at its natural end. If the tenant stays and the landlord accepts rent, the tenancy converts to a month-to-month arrangement subject to the 1-month notice requirement for future changes. For week-to-week tenancies, the notice period for rent changes follows the one rental period rule, 7 days notice. Now here's where Michigan's framework has a unique element, the Truth in Renting Act. The TRA, MCL 554.631, through 554.641, regulates the content of residential lease agreements and prohibits certain lease provisions that are considered unfair or deceptive. While the TRA doesn't directly regulate the amount of a rent increase, it affects how rent increase provisions in leases are evaluated. If a lease contains a rent increase provision that violates the TRA, for example, a clause that allows the landlord to increase rent at any time for any reason without notice, or a provision that waives the tenant's right to challenge an improper increase, the provision may be unenforceable. Courts evaluating rent disputes in Michigan may look at whether the lease's rent adjustment provisions comply with the TRA, and a provision found to violate the act can be struck down. The practical implication is that Michigan landlords should ensure that their lease provisions regarding rent increases are reasonable, clearly written, and consistent with the TRA. An experienced Michigan landlord-tenant attorney can review your lease template to ensure compliance. Now let's cover the restrictions that apply to all rent increases. Rent increases cannot be retaliatory. Michigan recognizes that landlords cannot use rent increases as punishment for tenants exercising their legal rights. While Michigan doesn't have a single comprehensive anti-retaliation statute as detailed as some states, the Truth in Renting Act and common law provide a framework for challenging retaliatory conduct. If a tenant makes a good faith complaint about habitability, reports a code violation, contacts a government agency, or exercises any legal right, and the landlord responds with a significant rent increase, the tenant may have grounds to challenge the increase as retaliatory. Courts evaluating a retaliation claim in Michigan would look at the timing of the increase relative to the tenant's protected activity, the magnitude of the increase, the landlord's treatment of similarly situated tenants, and any other evidence of retaliatory intent. A finding of retaliation can result in liability for damages and can undermine the landlord's position in any related legal proceedings. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the Michigan Elliott-Larsen Civil Rights Act, found in MCL 37.2101 and following, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, disability, familial status, age, height, weight, or marital status. Michigan's anti-discrimination protections are broader than the Federal Fair Housing Act. The inclusion of age, height, weight, and marital status provides additional categories that are unusual among state fair housing laws. The Michigan Department of Civil Rights investigates fair housing complaints and can take enforcement action, including ordering damages, injunctive relief, and civil penalties. A discriminatory rent increase can result in significant liability. The weight and height protections are unique to Michigan and deserve special mention. While it's unlikely that a rent increase would be directly tied to a tenant's physical characteristics, these additional categories reflect Michigan's broad approach to anti-discrimination law and remind landlords to apply rent increases uniformly without regard to any personal characteristic. From a practical standpoint, Michigan's rental market is diverse, with several distinct metropolitan areas and a wide range of conditions across the state. Detroit has undergone a remarkable transformation in recent years. While the city faced severe economic challenges, including bankruptcy in 2013, significant portions of Detroit have experienced revitalization. Neighborhoods like Midtown, Corktown, New Center, and the downtown area have seen substantial investment, population growth, and rising rents. Landlords in these revitalizing areas have strong pricing power and can implement meaningful annual increases. However, Detroit's recovery is uneven. Many neighborhoods outside of the revitalized core continue to face high vacancy rates, population decline, and limited rental demand. Landlords in these areas have minimal pricing power and must be conservative about increases to maintain occupancy. Detroit has also implemented a right-to-counsel program that provides free legal representation to tenants facing eviction. This program means that tenants in Detroit are more likely to be represented by attorneys who will scrutinize the landlord's conduct, including rent increase practices, and challenge any improper actions. Landlords in Detroit should ensure their practices are fully compliant with all applicable laws. Ann Arbor has one of the tightest rental markets in Michigan, driven by the University of Michigan, one of the largest research universities in the country. Student housing demand is intense, and rents near campus are among the highest in the state. The broader Ann Arbor market also benefits from the university's economic impact, healthcare, including the University of Michigan Health System, and a growing technology sector. Landlords in Ann Arbor generally have strong pricing power, though competition from new student housing developments keeps the market competitive. Grand Rapids has emerged as one of Michigan's most dynamic cities, with a growing economy driven by healthcare, including Spectrum Health and Mercy Health, furniture manufacturing, craft brewing, and a vibrant downtown revitalization. The rental market has tightened considerably, and rents have increased significantly. Landlords in Grand Rapids have reliable pricing power, particularly in desirable neighborhoods like Easttown, Heritage Hill, and the downtown area. Lansing, the state capital and home to Michigan State University, has a rental market influenced by state government, the university, and regional healthcare. Student housing near MSU follows the academic calendar, and rent adjustments typically occur at the beginning of each lease cycle. The broader Lansing market is moderate and stable. Kalamazoo, home to Western Michigan University and the Kalamazoo Promise Scholarship Program, has a unique market influenced by both the university and the scholarship program's impact on the community. The rental market is moderate with steady demand. The northern Michigan resort communities, including Traverse City, Petoskey, and Charlevoix, have seasonal rental markets with strong demand during summer months and more moderate year-round demand. Traverse City has experienced significant growth and increased housing costs, making it one of the tighter markets in outstate Michigan. Flint, Saginaw, and Bay City have faced economic challenges and population decline, resulting in softer rental markets with limited pricing power. Landlords in these areas need to be strategic about increases and focus on maintaining occupancy. Military-adjacent communities, including those near Selfridge Air National Guard Base and other installations, have rental demand influenced by military housing dynamics and BAH rates. One best practice for Michigan landlords: ensure that your lease's rent increase provisions comply with the Truth in Renting Act. Have an experienced Michigan landlord-tenant attorney review your lease template, particularly the sections dealing with rent adjustments, notice requirements, and the landlord's rights regarding pricing changes. A lease provision that violates the TRA is not only unenforceable, it can result in the tenant being awarded actual damages, plus up to $500 in statutory damages and attorney's fees under the Act. Another best practice, for landlords in markets experiencing rapid growth, like Grand Rapids and Ann Arbor, conduct thorough market analyses before implementing increases. These markets have seen significant new apartment construction in recent years, and the additional supply can moderate rent growth even when demand is strong. Pricing your units competitively relative to both existing and new construction helps maintain occupancy and minimize turnover. For landlords in Detroit, be aware that the city's complex economic landscape requires neighborhood-level analysis. A pricing strategy that works in Midtown will not work in other parts of the city. Understanding the specific demand drivers, proximity to downtown employers, access to public transit, neighborhood amenities, and building quality helps you set rents that are both competitive and sustainable. Michigan has specific requirements for manufactured home community lot rents under the Mobile Home Commission Act. Landlords who own or manage manufactured home parks must follow specific notice and procedural requirements for lot rent increases that differ from standard residential tenancies. These requirements include specific notice periods and content requirements that are more detailed than the general landlord-tenant provisions. For Michigan landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local housing authority. The authority evaluates whether the proposed rent is reasonable by comparing it to comparable unassisted units. Submit increase requests well in advance of the desired effective date. Michigan requires landlords to return the security deposit within 30 days of the tenant vacating. The deposit must be held in a regulated financial institution and cannot exceed 1.5 months' rent. While these rules don't directly regulate rent increases, landlords should understand that increasing rent doesn't automatically entitle them to collect additional deposit from an existing tenant. The 1.5-month cap is based on the rent at the time the deposit was collected, and any adjustment would need to be negotiated. For the complete guide to Michigan rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord Tenant Law series.